and that Jesse just happened to catch it as it was pointing at Sidney's forehead, at exactly that level, and that gun discharged and just happened to strike Sidney Park in the forehead. It's up to you, ladies and gentlemen, what sounds more likely. The only story that actually has evidence to back it up is the story presented by the plaintiff, because you heard about that evidence from Jules Sebastian. The gunshot residue that indicates the gun in Jesse's right hand. Blood spatter analysis that indicates Sidney was looking away, turning her head towards Jesse as the gun was being fired. Only one side of the story has elements of proof to back it up. And even though you heard from one person who was in that room on August 18th, you also know that his testimony cannot be taken at face value. It's exactly what Dr. Combs told you. And you saw for yourself, ladies and gentlemen, he put on a show for you today, but he was lying. And we know, based on conclusive evidence, a psychological expert, that he was capable of having done so. Fine for the plaintiff. Thank you.
Yes, Your Honor. Maisha Ishmael for the defense. May it please the court. Your Honor, opposing counsel, members of the jury, when you look at the facts, you'll see an accident. Today we heard a tragic story about two 11-year-old children who played with a gun. And on August 18, 2010, Sidney Park lost her life. As a defense, we sympathize with the Parks. We understand that nothing that is said or done throughout today's trial will bring their daughter back. But members of the jury, your job here today is very important. You're here to render a verdict based on the law. Therefore, it is crucial that you separate your emotions from the facts that you heard in today's case. And when you look at the facts, you'll see an accident. Now, the plaintiff, they had the burden of proof in today's case. They had to prove to you by a preponderance of the evidence, which is more likely than not these four elements that they brought before you today. Now, point one, that the defendant had custody and control over the minor child on August 18, 2010. Now, we know that both of these children were in the Parks home on August 18, 2010. So whether or not Hayden Durand had control over Jesse Durand during that time, they failed to meet that burden. But point two, the child committed an act of willful misconduct. Now, willful misconduct is intent. They had to show that Jesse Durand purposefully shot and killed his best friend on August 18, 2010. And they also had to show you that that willful misconduct was a direct and proximate cause for Sidney Park's death. Now, direct cause means but for. They had to show you that Jesse Durand loaded, aimed, and pulled the trigger of that revolver on August 18, 2010. And proximate cause means foreseeability. It was the plaintiff's job to prove to you today that based on what happened on August 18, 2010, it was foreseeable that Sidney Park would toss that gun and that that gun would misfire. That's what they had to show you today. And the plaintiff has not met that burden. What we've heard today is that Jesse Durand did not know that a gun could misfire. You heard that from Jesse Durand himself. He told you, yes, my mom explained to me that guns were dangerous if you pull the trigger. Not one witness today, not the forensic expert, not a police officer, not the gun safety analyst was able to tell you that Jesse Durand pulled the trigger on August 18, 2010. Not one witness. What you've heard today from Jesse Durand is that he did not pull the trigger on August 18, 2010, and what happened was an accident. Now, you also heard throughout today's trial that a gun could misfire. Officer Sebastian told you that on cross-examination. When I asked him, how can a person intentionally shoot a gun holding it like this? And Officer Sebastian told you a gun can misfire. Dr. Ash DeRosa also came before you and explained to you the factors that will make it more likely that what happened on August 18, 2010 was an accident. She told you what factors makes it more likely that two children were in an accident. The presence of a firearm. We know the Parks owned a gun. The accessibility of that firearm. Now, we heard today from Danny Brooks, from Andy Park, and from Jesse Duran that that firearm was accessible to two 11-year-old children on August 18, 2010. The age of the individuals. Now, we heard today that Jesse Duran was 11 years old at the time of this accident. Dr. DeRosa told you that children of that age group are the most likely to suffer harm from misfires and gun accidents. She also told you that children at that age have a natural curiosity for guns. Now, what we heard today is that Sydney Park and Jesse Duran had a conversation about playing with that gun on August 17, 2010. Now, the level of firearm safety training. We've heard no evidence today. Danny Brooks told you that these children were not trained on how to operate a firearm. Jesse Duran told you he was not trained on how to operate a firearm. Andy Park told you she did not train her daughter on how to operate a firearm. If two 11-year-old children wanted to play with a gun, had access to a gun, had no training on how to safely operate that gun, is it more likely than not that this was an accident? Yes. But that's the defense. We didn't have a burden in today's case. The plaintiff did. And they tried to prove to you that it was more likely than not that Jesse Duran suffered from psychopathy. And because Sydney Park didn't change the channel on August 18, 2010, that he intentionally loaded, aimed, and pulled the trigger of that gun. But that's not what we heard today. Now, the only person today who told you that Jesse suffered from psychopathy was Dr. Couples. And Dr. Couples based her conclusion off of 20 people, none of which we've heard from today in court. None of which we know their names. We don't know how long they've known Jesse. We don't know how well they've known Jesse. We don't even know how long they've been around Jesse Duran. But the person who told you that they babysat Sydney Park and Jesse Duran throughout the entire summer of 2010 told you that Jesse and Sydney were best friends. He told you that Andy Park thought that playing with Jesse was good for Sydney. Hayden Duran thought that the children were best friends, and the babysitter told you that both parents thought that it was okay for Jesse to play with Sydney. Now, if Jesse Duran was a psychopath, and if Andy Park thought that Jesse Duran posed a risk to her daughter, why would she allow Jesse Duran to stay at home with her daughter on August 18, 2010, alone with a gun in the home? If she thought Jesse Duran posed such a risk. The plaintiff needs to come up here and answer that question before you. Now, we also know that Dr. Couples graded Jesse Duran on the PAIJ scale. Now, she told you on cross-examination that the PAIJ scale is supposed to assess all minors on one scale. Now, ask yourself, does that make sense? Anybody under 18 can be evaluated on the same scale for psychopathy? So she's telling you that a 5-year-old and an 18-year-old can be evaluated on the same scale for mental illness or disability? Based on the things that they do and the actions that they're taking, they're supposed to be rational the same way from 5 years old to 18 years old? Does that make sense to you, members of the jury? But she did tell you that this test was created for people ages 12 to 16. Jesse Duran was 11 years old at the time of the incident. Jesse Duran was evaluated on a scale he was not even old enough to be evaluated on. Members of the jury, this was an unfortunate case of two 11-year-old children who played with a gun and that gun misfired. And Officer Sebastian brought before you the most compelling evidence to show you that Jesse Duran caught that gun and it could have misfired. Now, each person who knows how to fire a gun in today's trial told you that when you need to fire a gun, you need to have your hand on the grip of that gun, and you need to use your finger to pull the trigger. Officer Sebastian told you that he found no fingerprints on the trigger of that gun, none of which matched Jesse Durant. But the plaintiff wants you to believe that Jesse Durant intentionally pulled that trigger? Nothing about how Jesse Durant was holding that gun on August 18, 2010 shows you that he held that gun in a way to intentionally fire it. But what this does show you is that this is consistent with somebody trying to catch a gun. Arm outstretched, pinky at point 3, and index finger at point 4. Members of the jury, if you look at the facts, you'll see an accident. Find Hayden Durant not liable. Thank you.
Are we doing any rebuttal?
Yes, Your Honor. And can I inquire as to how much time I have left?
We're good at 35 seconds.
Yeah, begin.
You may.
Ladies and gentlemen, the facts of today's case have been very clear. I'd like to talk about two of the expert witnesses in particular. The first is what you just heard about Dr. Jules Sebastian and what he told you about this weapon. Opposing counsel just told you that because there are fingerprints in places other than the trigger and the grip, it's possible for Jesse to have fired the weapon. But you heard from Dr. Sebastian why that's not true. It's because you can't remove fingerprints from a grip because it's a tacky surface. He told you that. That's why he couldn't find any fingerprints on it, because grips are designed so that fingerprints cannot be lifted from them. The reason he didn't find any fingerprints on the trigger is because the trigger is too small of a surface. He told you that on cross-examination as well. It's very simple why there were no fingerprints. It's because it's impossible to lift them from those two surfaces. The fingerprints in the other parts of the gun simply indicate that it was loaded and that other people touched them. They also tried to discredit Dr. Couples by telling you they didn't have any access to the people that she interviewed, but ladies and gentlemen, you heard on cross-examination that she actually made available a list of people she interviewed to opposing counsel. And they could have made it available to you as well, but they didn't, because Dr. Couples interviewed teachers and playmates and people who really did know Jesse. That's why her testimony is reliable. Ladies and gentlemen, accidents and misfires, his opposing counsel was telling you about, they're not relevant to today's case. Jesse didn't accidentally take the gun out of the safe. Jesse intentionally held the gun. He pointed it at Sidney Park. He pulled the trigger. And that's why you need to fine for the plaintiff. Thank you.
We will finish our